Hi, this is Mark Wahlstrom. I'm the host of the Settlement Channel, and we have today in studio one of our frequent contributors, Matt Bracy, the former president of NASP, the National Association of Settlement Purchasers. And we've been talking, and Matt's done a series of videos on the recently issued bulletin, investor bulletin, by the SEC and FINRA that went over and discussed a lot of the issues in the secondary structured settlement annuity market, pension income streams, and factoring. Matt, thanks for joining us today. I had a couple of questions, and we just want to make this kind of a free-form conversation between the two of us. The structured settlement industry and the factoring industry has kind of this primal hostility that we've had for 15, 20 years, and it's an ongoing battle. Every time we think that this battle is won or this battle is over, you know, something comes up, and I kind of view this particular bulletin as sort of a resumption of some of the issues that I thought had already been long settled. Now that the SEC and FINRA appear by this bulletin to be looking to regulate, maybe provide oversight, at the very least comment and warn people about the issue of factoring and the purchasing of secondary market annuities. My question for you first is do you think this is a good thing, and really where are we headed with all of this?
You know, education is always helpful. It's unfortunate that the SEC FINRA bulletin isn't educational. In fact, it's the opposite of that. It's misleading. It's inaccurate at times. I think that information and education is always a positive. Where we're going with this, you know, I don't know. It seems unfortunate to me that, you know, the primary structured settlement marketplace, which is both brokers and insurance companies, you know, seem to be living in the past a little bit. I mean, to my perspective, and I have been in this industry for 14 years, to my perspective, you know, the fight is over, and there's no reason to fight anymore. And what should be happening is a dialogue that talks about how to best improve the product, you know, not nitpicking about things and not trying to derail each other. I mean, I just don't think that's positive. I don't know where it's going ultimately, but I know where it should go, and it should go more towards dialogue.
Matt, toward that end, you know, what struck me is really kind of the jumbled nature of, you know, the letter or the bulletin. I think it was kind of a mixture of apples and oranges. Factoring is, you know, it's highly regulated. It's in the tax code. It's in 47 states as an approved process through model legislation. Whereas the purchasing of income streams from secondary market annuities and factoring, that's a pretty recent and new phenomenon. To me, the investor bulletin, that makes sense in that particular area. I think there's a lot of questions in that area. I think there's some concerns. I think there's things people do need to be aware of. But again, you know, they're hinting at potential SEC and FINRA regulation. I mean, it's almost a warning shot. And as we know, the life industry, the life insurance industry, I should say, has fought for decades against federal intervention. They've been very happy with the state regulation model. But to me, this is almost unprecedented to be talking about this kind of concerns in this particular market. And I look at this as really kind of inviting regulation. Do you get the same sense that I do, that this may be just the opening shot of an attempt to regulate this area of commerce?
I do, and you know, with the product of, you know, factored structured settlement payments, they're either being sold as a security or they're not. If someone is in fact selling them as a security and has not registered and has not done what they need to do, then enforce that. But I think that sometimes they're sold, often sold to investors, and it's my opinion, and I believe that they are not securities when so sold. So either they are or they aren't. And if they are and they're not registered, then enforce it. And if they're not securities, then there's no place for that. Now, if someone is being lied to, if someone is being defrauded, if someone is being, you know, misrepresentations are being made, by all means, there are many modes of recourse for that, and they should be taken care of, and people should not be lied to. But I've never heard that. And so this seems to be a solution in search of a problem. And I don't know where it comes from. It does concern me, obviously, because today, the fact that there is a vibrant marketplace where investors are buying these is doing great things for people who need to sell their structured settlements. Okay, because what it's doing is driving down the price, which is good because investors want to yield, but there's a lot of investors who like this product. And that is doing good things in the marketplace, good things for the consumers. And but the consumer in this context, I mean the person who has structured settlement payments that has found that they need to sell some. Their price is better today than it would be otherwise. And so I think it does a huge disservice to them to unnecessarily cast aspersions on this product.
Well, see, Matt, now this goes back to the issue of price and pricing. The reason that these factoring deals get done is, I mean, they are high yield, they're high yield investments. Many of the older structured settlements, as you know, even after all the transactional costs and cuts that go into buying the income stream and working it through, when it comes out the other end, these secondary market annuities or secondary market income streams, they do provide a superior yield over, let's call them primary or, brand new structured settlements. Do you think there's a competitive jealousy or some concern between the primary structured settlement market about these vehicles? I mean, people are talking about them as structured income. They're talking about them as being as secure. It has the same safety and yield as far as the underlying income security of the issuer. And because these offer a new option and may make standard structures harder to sell, do you think there's some concern on the part of the primary structured settlement profession that these may emerge as an alternative to structures?
Maybe. I don't know what could possibly be done about that. The fact is that the factoring process allows you to kind of step back in time and take advantage of a much more attractive interest rate environment that existed, let's say, 10 years ago than today. And it's unfortunate that this would be seen as sort of a competing product, and I don't know what the answer is ultimately, but I will tell you that no one in the secondary market of structured settlement factoring wants to do anything to destroy the primary market. We all see the benefit of these. And in fact, the fact that 95% of people who are put in structures stay in them and like it is a huge testament to how good structured settlement brokers like yourself do. That process works. For the 5% of people who do have a need for liquidity, there needs to be a readily available avenue to access some capital, get a lump sum for future payments. And so I don't know what the end game is here. I'm not sure what the point is. It's unfortunate, and it's extremely unfortunate in this case because of all the negative connotations that SEC and FINRA are throwing around. We've heard negative connotations and frankly, bold-faced negativity towards the factoring industry from your side of the table for an awfully long time. I thought that was over. I'm not saying that there's a connection between the SEC FINRA bulletin and the primary market, but it sounds like a lot of the same old stuff that I've heard for a long time.
Matt, let's wrap up with this question. The core issue to me is that this is a valuable financial transaction, but the structured settlement is put in place very often with widows, orphans, blue-collar workers who've been traumatically injured. And many times these are people who may lack access to sophisticated financial advice. Many go into these structured settlements, and I'm just speaking as someone who's been doing this for 30 years and someone who's viewed the industry. They go into this without financial representation in many cases. Not so much now as 10, 15, or 20 years ago, but that's still the case where many times they're not looking at alternative investments. There's not a needs assessment or analysis being done. This is an insurance product, and it's a major financial decision. These are people under duress who are making profound financial decisions, sometimes without advice or, in some instances, without looking at alternative investment products or suitability of this particular product for their needs. Now, we've talked off camera about this, about suitability laws, senior protection laws. We've got annuity agents in certain states that have literally gone to jail for selling unsuitable annuities to senior citizens. And there's many laws that are being put on the books or expanded and toughened to protect vulnerable people, of which many of these people who settle cases are quite vulnerable. FINRA, state regulation, the SEC, is this a slippery slope that the industry is going down by inviting them to come in and comment on the secondary market? And really, what are we putting people into here? Are these suitable investments in the big picture? And I'm talking about structured settlements. And is asking for the big hand of government, really good idea? Are we possibly going to cause bigger problems in the primary structured settlement market as a result of this?
I do agree with that. I've been asked before about what was characterized as a wet ink transaction, which is where, as I understood it, the question at the time was someone is put into a structured settlement and within months they're trying to sell payments, they're trying to factor payments. And the complaint came and the issue was, well, don't you think that there should be a bar on that, or don't you think that they should not be able to do that? And my answer is absolutely not. And for two reasons. Number one is perhaps there's a problem with the way that the structured settlement planner looked at the case and whether or not they really tried to keep the person's best interest in mind when they set it up. That's number one. And number two is, let's assume they did. Let's assume you did your absolute best, perfect job. If you're not able to predict the future 10 years down the road, you're actually not able to predict it 5 minutes down the road either. Okay? You can be better closer in time, but you're not perfect. And so sometimes you're going to miss. And when you miss, the beauty of the world as it exists today is those people do have an option. But you can miss, it doesn't matter if it's 6 months or 6 years. If you're wrong, you can be wrong. You can be wrong close in time or far off in time. So I do think that, there can be more trouble than it's worth oftentimes looking at extra regulation, or sometimes people talk about licensing. The fact of the matter is that every single transaction that gets done in the structured settlement factoring world is court approved. Every single one. And so a judge looks at that transaction, often stares at the person in the eyes, knows them because they live in the same community as them, and decides whether or not this is in their best interest. That is a level of scrutiny that it doesn't exist anywhere else. It doesn't exist for any other kind of financial transaction, but it exists in this world. I don't necessarily think it's great all the time. I think these people are put under a lot of pressure. And I think it's a horrible experience for them often, and it's unfortunate, but that's the world we live in today. The factoring world has adjusted to that reality. People still have a need to liquidate when they have a need to liquidate.
Matt, thanks. This is going to be a hot topic now and in the future. And really, it's a question of what is best for the injury victims. What bothers me many times is that this becomes a turf war between the factoring profession, the primary structured settlement market, hedge funds, insurance companies. You've got powerful people fighting over a market, and often I feel that the injury victim, the family, the person who's making a tough decision kind of gets lost in the process. And Matt, I really appreciate your coming in here and having a frank discussion about this whole process today.
That's right, there absolutely is. And no one will shed a tear if the factoring company goes out of business, or no one's going to care if the structured settlement broker can't do their business anymore. What they do care about and should care about is that injured person or their heirs or beneficiaries, and they should care about how they get treated through this process, and they should care about their privacy and their rights and their dignity as they have to make this decision.
Thank you, Matt.
Thanks, Mark.
And thank you for joining us this week here on the Legal Broadcast Network. I'm Mark Wahlstrom. We'll see you again next week.